Welcome to 5 at 5 with Stone Law Offices. I'm attorney Brendan Bybee with 5 minutes on beneficiary controlled trust. Now, many attorneys may have different names for some of the features that they like to put into their trusts. And you might even there might be another attorney that has something they call a beneficiary controlled trust. It's a little bit different than ours, or maybe very similar. But set any of that aside. What I'm going to be talking about is our version of a beneficiary controlled trust, and I want to talk to you about what that means and why you might want to include that in your trust. Now, with your estate plan, with your trust, when you pass away, you're providing for all of the assets that you've collected and put into that trust to pass down to another generation or other beneficiaries, regardless of whether they're children, grandchildren, friends, family, otherwise. Now, when you're passing property down to an individual or a charitable entity, any kind, there's two major ways in the first place, decisions to make about how that property is going to pass down to them. You've passed away, all the affairs have been wrapped up, now the property is going to them. It can either go outright to them, meaning they get a check, they get a bundle of cash, and it's theirs and they're gone, and the trust has nothing more to do with them. They have nothing more to do with the trust. Everybody gets their property that way, their inheritance that way, then the trust essentially terminates at that point. The other option there is instead that for at least some, if not all of the beneficiaries, they're going to get it in a trust. So that trust is not a separate document that necessarily has to be prepared, but that trust is provided for in the underlying trust document that you have. So it says, okay, this child is going to get this, for example, it's going to get $250,000 in a trust, and then you get, from that point, like I said, you have two major options, outright or in trust. Is it going to go directly to them? It's their asset from that point forward, regardless of their circumstances, or does it go to them in trust? If it goes to them in trust, there are a number of different ways that can be set up. You can have it set up without, where that beneficiary never has any rights to make any decisions in regard to that trust. Maybe set up where it distributes over time, although we do probably less and less of that. But at one time it was very typical to say, oh, they're going to get a quarter of it at age 25, the next a third of it at age 30, half of it at age 35, and the remainder at age 40. So it may have split out over time and give it in big chunks along the way. In some cases, it may be something where it distributed out a little bit each year over a course of 10 years, and it's all been distributed. There are a number of ways that you can distribute it if you're distributing it in trust. But the beneficiary controlled trust is something that we do to try to provide the beneficiary with some advantages in the way that they get that inheritance, while protecting that asset, again, providing some, so we really want to give them some control while not giving away the advantage of some asset protection features that you have in that as an inheritor under the trust. Now for your trust, the assets, it's a revocable living trust, that's a grantor trust. The property is considered to be yours for all legal and tax purposes during your lifetime. But when that property passes to a beneficiary on your death, the trust that they receive is a different vehicle entirely. This is an irrevocable trust, and now it can have spendthrift provisions that are meaningful, that restrict any creditor that they might have, whether that's a divorcing spouse or a business partner that they had, or they got in a car accident or something like that. Now those people who want to get to that inheritance to get recovery, it's a spendthrift trust. That means they can't get to it. They can't get to anything in that trust until it's distributed out to them. Now with a beneficiary controlled trust, this is a situation where you don't necessarily want to fully restrict that beneficiary from any involvement in the trust. Perhaps you want them to be involved. You want them to be able to make some decisions regarding that. But you also want them to have the benefit of the asset protection, that they can have that secure fund that regardless of what happens to them in their professional life and their marital life, or otherwise, that's going to kind of be this secure, safe fund that is protected from any of those unfortunate events that may occur for them. So the controlled side, that for the beneficiary means, at a certain age, they get the opportunity to be a part of the trust administration as a co-trustee. They can learn about the trust administration and management. At a certain age, they may then be able to have sole control over the investment of the trust assets. So they can say, I'm going to buy this stock, sell this stock, reinvest it over here, I'm going to invest it in this business, I'm going to purchase this property for the trust. So they can have that control. You can give them that control at a certain age where you don't really have any concerns, at least at a certain age after they've had some training. You don't have concerns about them making those decisions. You want them to be able to make those decisions. But then what we do in terms of maintaining that protection is to avoid arguments that, well, they have full control over the trust and the beneficiary of this trust. They have control over distributions. Then I, as a creditor, want them to distribute that to me. I want the court to tell them they have to distribute to me for their debt. So what we do there is we say, okay, the beneficiary has a trustee that's only there for distribution decisions. They may even have the opportunity and the right to decide who that trustee is once they're of a sufficient age. Otherwise, it's the trustee that you've already named there. But that distribution trustee is the only party that can say, okay, yes, this $1,000 goes out of the trust to Johnny or Susie or whatever, or this is going to actually go to the university to pay for their education, or this is going to go. We've got a trust property in here, a real estate, and the beneficiary is going to be able to use it as their residence. That distribution trustee stands in that place to essentially make sure that the beneficiary doesn't have so much control that creditors are able to attack and get to those assets, but they do have all the other control that they may have without putting the assets at risk, to be able to decide what's the composition of this trust going to be, what's it going to be invested in, and when are those trades or sales going to be made to try to build this fund up or to use it strategically. This can be a great boon to a beneficiary to provide that flexibility that they really can have a lot of control, and yet know that because you've put the structure in place, if they have anything that goes wrong in their life, if they have any personal circumstances that would put those assets at risk, that they are secured through the beneficiary controlled trust. If you think something like this would work well for your beneficiaries, if you have it going outright to them, or you have it going a really restricted way to them, and you think, you know what, I want them to have asset protection. I want them to have this safe and secure fund. I also want them to be able to make mature decisions with it, and I trust them to have some certain amount of control. This is something that we can help you implement for your trust, for your estate plan, for your beneficiaries.